Describe some mistakes that people make in their estate plan.
Absolutely. I do free reviews, so I get to see a lot of different types of estate plans. A lot of mistakes are made by people who try to do it themselves, which always amazes me because you only die once. So if you do it wrong the first time, there's no way to correct that later on. You do your taxes wrong, and the IRS gives you 3 years to amend. You do your estate planning wrong, and unless you can resurrect, there's really no way to go back and fix it. That's the biggest mistake is the idea of do it yourself. Do it yourself heart surgery? No way. Do it yourself estate planning. For some reason, people think it's okay. But some of the common mistakes that even attorneys make when I review these are amazing. For instance, sometimes people think that it's okay, well, I'm just going to put my son on my house. And then that way when I die, my son just gets it. That's one of the biggest mistakes I see among especially retirees. They put their kids on their house because their kids are grown and they figure, okay, that's a great way to avoid probate. The problem is, number one, as soon as you deed half interest of that property to your child, you've given a gift of a half value of your property, which means you owe gift tax on that. You're only allowed to gift $13,000 to any one person in any 1 year. So if you've given more than $13,000, if you live in a house worth more than $26,000, which nowadays who knows, but then you've given a gift that you need to pay gift tax on, and the IRS, if they catch you, will levy a penalty. Now, in addition to that, when you die, there's something called a step up in cost basis. If you do through a will or a trust, if you deed property through a will or a trust, the property steps up to the value as of date of death, or 6 months after date of death, whichever the person chooses. And then when you sell the property, if you sell it for that fair market value, you pay zero capital gains tax. The beneficiary would pay zero capital gains tax. However, if you transfer a property during life, the person who receives that property, they take the cost basis of the initial purchaser. So if you owned a property for 40 years, if you've lived there for 40 years, you probably bought it for, let's say, $50,000, and maybe now it's worth $400,000. Well, now you owe $70,000 in capital gains tax when you sell it. So that's another issue, is they don't take into account the gift tax, they don't take into account the capital gains tax. In addition, when you put someone's name on your property, you're doubling the liability. So let's say that you live in a house and you've homesteaded that house. Florida homestead protection is fantastic. It's constitutionally protected. So you think you're okay, but you put your son's name on the property. Well, now your son gets in a car crash and they sue, and the lawyer suing is trying to figure out, well, what property does this guy own? Well, the half interest in your house that he owns is not protected. So a lien could be put against your house where it otherwise would have been protected from all liens other than liens arising out of the house. So that's another issue, asset protection. And then from the other side of that, I even had one client that came in. His mom put his name on her house. He was trying to file bankruptcy. He had no assets. The bankruptcy court rejected the bankruptcy because they said he did have an asset, a half interest in her house. So all of these things come into play. And in addition, when the asset transfers at death, if the person whose name is on the deed doesn't do something with it at that point, then the asset would eventually be probated and end up with that person's spouse or that person's creditors or somewhere else. So that is one of the biggest mistakes I see people make. And the rule of thumb is, if you're not married to the person, don't own something with them. So there is good reason, sometimes not good reason, for husband and wife to own assets together. But if you're not married to the person, you should never own anything with them. There are other ways to allow children to have access to assets without giving them ownership. Now, another big mistake I see people make is they go and they get this trust made, and the trust is done correctly. It's beautiful, but they don't fund it. A trust is like a safe. Imagine making this fireproof, waterproof, burglar-proof safe. You drill a hole in the master bedroom closet floor and you put it down there, you put carpet over it, but all your valuables are on the dresser. Doesn't make any sense. So what we have to do, and what we walk our clients through, is once the trust is created, once that safe is there, we have to take the assets, the house, the bank accounts, the brokerage, the retirement, the life insurance, make sure they all flow into that trust. So that way that trust protects those assets. Another huge mistake is not updating the estate plans. Estate plans are not made by Ron Popeil. They are not set it and forget it. They need to be tuned up every now and again. If you think about what your family looked like 15 years ago versus what your family looks like now, It's different. People are different. Assets are different. Concerns are different. So if everything changes over a period of 15 years, why would you wait 20 years before updating your estate plan? So I tell my clients every 3 to 5 years we do a little tune-up. We check it for changes in the law. We check for changes in the assets. And then I ask my clients, did anyone in your family or named at all in these documents die, have a baby, get married, or get divorced? Because that could change everything. I mean, you yourself had 3 years ago had a minor child and now have a child of majority. So it changes everything.